Okay, there's been a fair bit of discussion on our pages recently about an incident which occurred up in Newcastle where a young father purportedly went to defend his home and his daughter, and another person ended up deceased, and he's subsequently been charged, brought before the courts, and either been refused bail or hasn't applied for bail. Section 418 of the Crimes Act in New South Wales states when we can use self-defence. It's as stated on this page regularly, in circumstances where it's reasonable and necessary, in the situation as you perceive it, to take certain action to defend yourself, your family or your property. If your actions are excessive or deemed to be excessive, then you may have a problem establishing that you acted in self-defence. If the person is deceased, there are certain provisions in the Crimes Act, certainly under section 419 and 420, that make it harder for you to prove or to establish that you're acting in self-defence. In relation to the current scenario, we need to make it clear that we don't act for either party in relation to this and have no knowledge other than what is contained in the local media as of about the 1st of April 2016. But what we can indicate, and what's clear, that using reasonable grounds, it's harder to claim self-defence if you pursue somebody, if they're running away from you. It's harder to claim self-defence if somebody is being restrained or has surrendered. It's harder to claim self-defence if somebody is severely injured, for example, having their neck broken or deceased. What you always need to be able to establish is that your actions were reasonable, necessary and proportionate in the circumstances that you found yourself. You must believe that, and in addition to that, a jury must be able to believe that.